The third defendant is Ahmed Sattar. Both of the gentlemen are Egyptians, but American citizens. Ahmed lived in Staten Island, worked for the United States Post Office, and had 4 children, worked 2 or 3 jobs along with that, but the government wants to characterize him as a postman by day and a terrorist by night.
Now, what was his job in connection with the Rahman case?
He had been a court-appointed paralegal. In cases of this sort, especially with the sheikh, there was tremendous amount of translation to be done. And it all had to be done orally because the sheikh does not read.
Blind.
He is blind. You would have had someone to had to put it in Arabic Braille in order for him to have it in any other form. So as a result, we had 2 or 3 young men who basically came in and translated tapes, etc. He was compensated by the court, he was appointed by the court, and then by the end of the case, he sort of became our unofficial paralegal. Even though he was no longer being compensated, he was the one that remained the link to the family. He was the person who, we could go to if we needed to go to the community for something, the U.S. community.
Right. Tell me, when the surveillance began, when did you realize the surveillance was happening, and why did they have the right to have surveillance over an attorney and their client?
February of 2000, they received permission from a court that is known as the FISA Court, F-I-S-A, Foreign Intelligence Surveillance Act Court, to listen to the sheikh and also to listen to Ahmed Sattar. They actually have been listening to Mr. Sattar for many years before that, but this was the first opportunity they had been given to listen to the attorney-client conversations, both in the jail and over the phone. And this was not just my conversations. This was Ramsey Clark's conversations with the sheikh, Abdeen Jabbar's conversations, all of us. And they installed special equipment in the jail to do this. They listened to it in 2000, then they listened again in May of 2000, which is when the sheikh asked us to do the press release that becomes the crux of the other charge. The FISA court is infamous for never turning down any warrant that was ever placed in front of us. And then, of course, under the Patriot Act, they don't really need a FISA court. They can listen to anyone, anytime, in any place, just on the signature of the Attorney General.
So when did you become aware that this was going on?
Only after I was arrested. We had no idea. We were not given any notice of this. That's
now. What about the first time that they notified you that they felt that you had breached the SAMS?
Well, actually, we also have a small part of our case is the duplicitousness of the government, their ability to tell lies when it furthers their goals, but that I'm not allowed to say, oh yes, I'm going to live up to these regulations. And then when I'm confronted with a situation where I can't live up to them, that they won't allow. But of course, they're allowed to lie at will. What happened was they wrote to me and said, you can't visit, you can't have any more phone calls.
Oh, they withdrew your ability to be his attorney.
Well, not his attorney, but not to visit, not to communicate, which meant that I could be with Ramsey Clark or whatever else he could do. But the fact was that they said that. Meanwhile, they had their busy little henchmen in there setting up the tapes, setting up the video and the oral. And then when I went back in, they said to me, well, you can go back in, but you have to sign the same agreement that you signed before. They had added a paragraph. They had put a paragraph saying that I understood why this was so important to keep the sheikh quiet, because he had done this, 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 and this. And I said, I don't know that he did this, this, and that. That's what you think he did. That's your allegation. So I changed it all, and then I signed it. Of course, they also promised that I could have attorney-client conversations with him, where they had no intention of allowing attorney-client conversation.
They say that you materially assisted in terrorism.
Right.
And something that's confused me, I've been at the trial this week, is what act of terrorism happened as a result of what you did?
Well, that was the missing ingredient in the prosecution's opening statement. They had a seamless web, a beautiful narrative but it was lacking the punchline, and the punchline is that nothing happened. And even Ashcroft, when he came to New York to announce the indictment, he was asked, well, after she made the press release, what happened? He said nothing. And that is the fact of the matter. Nothing has happened.
Because in court, he's mentioned many horrible acts of terrorism, but when I went home and looked up the dates, they were before you made the press release.
Way before.
So
and they've thrown in, and the judge has permitted them to do this, they've thrown in, you know, the kind of things that could happen might be something like the U.S. Coal, or might be something like the group in the Philippines, Abu Sayyaf, kidnapping tourists, but they don't have anything to do.
But nothing did happen as a result of the press release.
Nothing did happen.
Okay,
Absolutely
because I wasn't
not.
really sure about that.
Right. No, absolutely not. And actually, it was a misinterpretation. They were always fond to say he called for an end to the ceasefire. Well, an end to a ceasefire means start firing again. But actually, he said, I personally have questions about the efficiency of the peace initiative, because the group had unilaterally said, we are not going to have any more armed struggle against the Egyptian government.
Explain the difference and the distinction between an intelligence investigation and a criminal investigation.
There was a law that said that you cannot commingle intelligence investigations information with criminal investigations information. In other words, if they're listening to someone and he's talking about politics in Palestine, but then one day he gets a call from Joe Blow who says, oh, by the way, I'm delivering all of the hashish next week. They can't take that information in the old days and say, here's a criminal case for you guys, go get them. I have the tape here. Those tapes were only to be for intelligence. Right. Now, under the Patriot Act, that wall is gone. They can do anything, they can commingle, they can do almost anything as long as they have the magic words, national security. So what we were saying last week was they hear this press release, they decide it may be actionable, that is, they may be able to get an indictment on this. Because the law, the materially aiding law, has been struck down. They have to connect this to some kind of terrorist activity, I think, to satisfy a jury that this should be a conviction, that this should be a guilty.
This has been Joan Moossy for INN World Report, speaking with Lynne Stewart.